Hi, Gordon Miller. I'm not a lawyer, so these are matters of law of great interest to me, but I'm not well informed. But one thing has come up and you alluded to it again, and it's certainly evident in my field, in the broader policy area, and that part of this change that's come across, in the last 10 whatever number of years, not that in terms of our lifetime, relatively recently, relates to this asymmetry in wealth that is brought to play. And it's certainly true in the just the general public policy area too, where, as you just said, if you have $500,000 that you can just freely spend, you can drive this into the ground. And is there any way of getting at the asymmetry of wealth that comes into play? I haven't heard any discussion on that tonight, because, I mean, in the one case with David, we're talking, I believe it's $1 billion development, and, $1,000 million is so much money. 1% or 0.5%, it represents a tremendous amount of wealth. And none of us, and some of the speakers here tonight said, it took you a year to raise $35,000. I myself have been involved in those things, and it does take that long. So it's this asymmetry of wealth that has changed the playing field. Is there any way that can be dealt with?
There's no effective way. We, at one point, contemplated in this country having a legal aid system for civil cases. We do in a limited sense for divorce and family, various kinds. But the legal aid systems have been starved to the point where what is being paid really provides you with second-rate lawyering. It's just not enough money to sustain a serious legal defense or a legal attack. Second, there are some regimes which could provide separate funds for particular purposes. As for a while, the federal government maintained a fund for those who wanted to raise equality challenges. It paid at a very low rate, too. But other than those models, I don't think so. You could put a tax effectively through the OMB on fees, saying that everybody has to pay something into a fund that's going to be available for challenging projects from the public perspective. But I suspect that a fee large enough to make a difference would not matter. The rich have always had their way with the courts. That's everything that I know. It's not perfect. They don't always get their way, but they tend to. And I'm not sure you can effectively deal a blow to that.
Gord, can I just add to that? Gord, I think you raise a really important issue in relation to SLAPP suits, and that is, how do you deal with powerful interests to bring the lawsuits? And it's generally against a little guy who doesn't have the resources. And that's been, I think, one of the most difficult sticking points of SLAPP suits. And the way that some states, and I think Quebec also has this in its legislation, the way they've dealt with this is having what's known as cost advance, that you can apply to the court to have the SLAPP filer fund the defense. And if the SLAPP filer is successful, at the end of the day, then those costs would get reimbursed. Otherwise, it's too bad. So that's one of the ways that they have dealt with that issue, which is really how do you fund the cost of litigation? It's cost advance. Yeah.
It was done most recently in a couple of Indian cases out of the West Coast. And the Supreme Court of Canada has recently made it more difficult to get costs in advance than it was. It's an interesting technique, and it's, again, one technique which might be useful, but it's not going to be the solution to all the problem.
Clay, you recently had the privilege of being before the Administrative Tribunal, the Ontario Municipal Board. We do things differently here in Ontario. The real environmental action in a lot of cases is before either the Environmental Review Tribunal or the Ontario Municipal Board. But what I found, and I'd like to hear your comments on this, is the asymmetry between the court process with respect to costs, which are usually over as a matter of a written record or are done in half a day. We were 17.5 days on this thing. If you counted the motion days, we were over 20 days. Do you feel we need to address the problem in the administrative tribunal context, where our cases go on for 6, 8, 9 months, whereas court cases in the United States are over in a matter of days? And doesn't that put an unfair burden on the public? When you add in the cost claim, isn't this part and parcel of SLAPP? And isn't it strange the way we litigate at the OMB?
It's strange, but I think it's by default. OMB costs are supposed to be rare and modest, and very, very, very few in number. But you've got to have a tribunal that's willing to enforce that. For example, I was in a criminal case, where the bail hearing went on for 60 days. Unheard of. Bail hearings take an hour or two. And it was just a Crown that was willing to abuse the system. Unfortunately, in the OMB, everybody's willing to abuse the system if it gets them the pot of gold at the end of the rainbow. So I don't think there's anything other than judicial discretion that protects you on that. But you're right, it's a horrible abuse, bankrupting in terms of the economics of it. And the fact that it came out in the end with a wonderful result really is of little consolation.
Anyone else?
I mean, it obviously would be fabulous to have a whole chunk of money that was totally independent of the OMB government of any kind to hand it out to SLAPP-suited defendants. But another mechanism would be to use pro bono law and the willingness of many lawyers. I mean, I've acted a lot on a pro bono basis to take on these cases. We can only take on so many, obviously. But with an organization like that, if it's made a focus, it could become an important element of the mix. I agree we need all those changes to address that asymmetry that Gordon Miller mentioned earlier.
I see real problems with that. I have great respect for pro bono law, and for you personally. We've been friends for a long, long time. But if you come to me and say, I want 60 days of your time in court, day after day, and I'm not got any money to pay for it, and I want you to do the research and the evidence gathering necessary, it'll cost $30,000, $40,000 in expenses. We haven't got any money for that either. And you'll spend a couple of months preparing for these hearings, because you've got to do it responsibly. Nobody in pro bono law can do that for free. It's just, you very quickly outsize yourself from the ability of anyone acting for free to do it. So I think pro bono law is wonderful, but I think it really is wonderful for little small problems. For the guy who's got a problem that's going to take a day to solve. I don't see it as being a solution of this kind of deep, fundamental, difficult problems. Thank you very much.